Good afternoon. Welcome to the second Farrar's Building webinar of 2025. My name's Tim Found. I'm a barrister at Farrar's Building, from where I've practiced since I was a pupil barrister nearly 20 years ago. I specialise in personal injury and clinical negligence litigation, and as such have read thousands of medical legal reports, led many conferences with experts, drafted more agendas for joint discussions than I care to remember, and had the opportunity to cross-examine many experts at trial. Today, I'd like to talk to you about why it's not easy being a medical legal expert and how we can all learn from judicial criticism of experts. In delivering this webinar, I hope that it's helpful to two audiences: the civil lawyer, whose caseload may include personal injury and clinical negligence claims, and the medical legal experts instructed in such claims. I suspect our distribution list is weighted in favour of lawyers. And to the lawyers, I would say that this webinar will go on to the Farrar's Building channel on YouTube. So please feel free to refer your medical legal experts to it. Hopefully it will be helpful both to those starting out as professional experts and to those who've been doing it for some time. The structure of this webinar is hopefully somewhat similar to a trial judge's judgment. Firstly, the evidence, in this case, edited highlights of judicial feedback contained within judgments, mainly from the last 12 to 15 months, but with a couple of older ones as well. Secondly, the relevant law or the guidelines, the essentials, as I'm going to term them, for being a medical legal expert and where to find those. Thirdly, applying the guidelines to the evidence to see what can be improved upon. And finally, a canter through some practical tips from my own recent professional experiences. I'm afraid there won't be an opportunity to ask questions as part of the webinar today, but I strongly encourage anyone with questions to contact me via email or phone, and I will do my best to answer. My contact details are on the final slide of this presentation. I've heard it said that in recent years, both the quality of medical legal experts and the quantity has decreased. I've also heard it said that it's increasingly undesirable to be a medical legal expert. Both of these contentions might be corroborated by the increase in judicial criticism and the increasingly explicit nature that of that criticism in recent years. Here follows the sort of judicial feedback that experts and lawyers don't want to hear about themselves or about the experts that they've instructed. Deep breaths, wincing, gulping may all occur when reading these nuggets of judicial criticism, so here we go. The first case I'm extracting from is a relatively friendly bit of criticism, as opposed to some that we'll see later on. Simple, straightforward. I've found Mr. Y to lack the independence required of an expert and to be unreliable. In a different case, we have slightly more criticism. In this case, Mr. B's preparation has lacked the attention to detail which the case demanded. I regret to say that the overall impression was of a rather casual approach to the issues in the litigation. This is in stark contrast to Mr. C, who gave the impression of having considered the issues in the case with real care and who provided thoughtful and measured responses to the questions posed. Mr. C was the counterpart on the effectively instructed by the other side of Mr. B. In the next case I'm quoting from, we have a Dr. D. Dr. D readily accepted that integral to his reasoning was that he did not believe the claimant in this case as to the symptoms he had suffered. Although he said so with less clarity, the same is likely to be true as to the claimant's account of the incident. In the judge's judgment, it is entirely outside the remit of an expert to decide which witnesses of fact he believes or disbelieves. Following that up in the same case, However, in failing to appreciate or deal with the possibility that the account of the symptoms provided by the claimant might be true, Dr. D has deprived the court of what evidence he might have been able to give if the court accepted the truth of that account. In other words, Dr. D gave expert evidence only on the factual scenario, let's call it scenario A, that he accepted, namely that he didn't believe the claimant. Because he didn't countenance the possibility of the court finding the alternative factual scenario, say scenario 2, where the claimant was to be believed, Dr. D didn't provide the court with his expert opinion on the basis of scenario 2. As we'll see below, that is a serious failure, and one that we as practitioners, certainly I see all too often. I suspect you will too. So on the face of the case reports that I'm about to refer to, the remaining negative judicial sound bites appear to involve very significant failings, often multiple significant failings, with experts struggling at trial to extricate themselves from deep holes. You might be getting an insight as to the sort of holidays I've been thinking about whilst preparing this webinar. The lawyers in the audience may have noticed already that, unusually perhaps for this sort of continuing professional development, I haven't referred to any individual case names or citations so far, and I'm not going to below. I'm also anonymizing throughout this webinar the names of experts and judges in these materials. The main reason for this is that this webinar is intended to be a learning and improvement resource, and that aim, to my mind, is not achieved by naming those who have been the subject of judicial criticism. Those in the audience can be assured that where cited text is set out above and below on these slides, it comes directly from reported cases or transcripts of judgments where the case wasn't reported. And most all practicing lawyers in England and Wales will have access to online resources which will enable them to track down any cases which are of particular interest from these slides. But if you have any difficulty in doing so, feel free to email me and I will help where I can. So on to rather more serious criticism of experts. In this case, Mr. K was found to be a partisan witness who unusually agreed quite early on in his cross-examination by claimant's counsel with the contention that he'd lost all independence and objectivity in the case. Mr. K said and wrote quite a lot which was not justified on the evidence or which was directly contradicted by the evidence, and was actively seeking to influence the court to make a lower award to the claimant than that which was justified. Mr. M, the judge said this of Mr. M: in my judgment, Mr. M did not reflect sufficiently on the inconsistencies between the history he obtained and the other sources of evidence. He also did not appear to reflect on the evidence he heard at trial. And this was particularly significant in Mr. M's case because he was present listening to the claimant give oral evidence. And the judge in his case said this: the main point of an expert medical witness being present while the claimant gives evidence is so that they have heard that evidence firsthand and can weigh it in giving their opinion evidence. Mr. M simply did not do that. He was asked about evidence the claimant had given about doing star jumps and about the length of time he was on the ice. Mr. M replied with comments such as, "I have no idea, you would have to ask him." The judge, seemingly not impressed by that, said, "The fact is the claimant had been asked in court in the presence of Mr. M. Of course, any findings of fact remain for me, the judge, not for the experts, but I would have expected Mr. M to take on board what he had heard and to think about whether that altered his opinion in any material way." He did not give the impression of doing that. Rather, he appeared to be keen to uphold his history and to dismiss features that might in any way undermine what he had said in his report. In the next case, this is a case where I've only taken a snippet of some very extensive judicial criticism of Dr. O. Dr. O, I'm afraid, was subject to 7.5 pages of High Court judge criticism in the judgment of this case. Uh, all of it, perhaps surprisingly, less serious on a one-by-one analysis of the criticism than this. In my judgment, no reliance whatever can be placed on the reports and opinions of Dr. O, who was prepared materially to mislead the court by passing off the views of another person as her own, by lifting large passages from that person's article and setting them out in her report as if they represented her own views without acknowledgement or reference to the originating source. Now to a slightly older case, still under 10 years, under 10 years old. This is an unreported case, and so this text comes from the transcript of the judgment. And the judgment says this: the opinions of an expert doctor in a case such as this, who has so strikingly demonstrated no real knowledge or proper understanding of the claimant's extensive and highly relevant pre-accident history, are of little or no value. This is not a case where the expert was silent. Mr. P positively asserted that the claimant was fit and well prior to the accident. And I'm afraid there's rather a lot to learn from the judicial criticism of Mr. P. So there are 2 more slides of it. The judge continued, in his reports, Mr. P was dismissive of the views of other equally well qualified doctors, and moreover in terms that were at best offhand, at worst rude. Mr. P did not confine his comments to the opinions of Mr. Q, the defendant's pain expert, but was caustic about the defendant's expert psychiatrist as well. When he gave evidence, Mr. P was dismissive of those who did not agree with his rigidly held opinions. When counsel for the defendant put the following proposition to Mr. P, there is no generally accepted or understood pathology or physical explanation for CRPS, Mr. P replied, absolute rubbish and nonsense. This dogmatic approach is inconsistent with the obligation on an expert witness to consider and acknowledge where there is a range of opinions, even if the expert for his own reasons rejects them. In this instance, Mr. P flatly rejected the proposition that a diagnosis of CRPS was controversial, a proposition the other 3 medical experts accepted. And finally, from Mr. P's case, this slide. The content of Mr. P's evidence was combative, and he repeatedly acted as an advocate for the claimant. There was a lack of balance and much argument in his evidence. Rather than answer a question directly, Mr. P would often sidestep and respond with an argument to support the claimant's position. The contrast between Mr. P's determined advocacy of the claimant's position and the more considered and balanced evidence of the other 3 medical experts was striking. The other experts listened to the questions and answered them briefly and as best they could. Mr. P did not. And now in my final bad news slide, we have Dr. S, who in oral evidence accepted himself that he was overzealous in his use of language from the outset, and that when he reread his reports in preparation for trial, he winced and thought he could have been a little bit more reflective and kinder and provided a little bit more range of opinion. The judge said, I was troubled by the extent of departure of Dr. S from his Part 35 duty, and I considered that it lacked the appropriate necessary balance, probably as a result of his initial views of the claimant's credibility. Because Dr. S did not believe the claimant from the outset, Dr. S did not consider the alternative case in respect of pain management. And we've seen an example of that already. If you are an expert watching this webinar, it's understandable if you feel a little bit like this deer. Let's take a breather from all of this criticism. I'd like, if I may, to use the Zoom polling function today. I confess I've not used it before, so hopefully this will go according to plan. I've got three polls initially that that will just let me know who makes up the audience today and who I'm talking to. And then I've got two later little quiz questions, which hopefully will confirm to yourselves that the materials that we're covering have been absorbed. So the first question that I have for you is about you as an attendee. Are we mainly lawyers? Are we mainly experts? Are we neither? I'm very impressed at the rapid rate of response. Already got 80% of response. Thank you very much. I can tell you we are largely lawyers here today. We have a couple of medical legal experts, and we have a few who are neither lawyer nor medical legal experts. Thank you all for coming. My next question is to the lawyers in the audience, and that is as follows. Do you mainly do claimant work, defendant work, or both, please? Or say not applicable if it's not applicable. Very hot off the mark. Well done, everybody. So we have 30% claimant lawyers, 65% defendant lawyers, 2% who do both claimant and defendant, and 3% for whom the question is not applicable. I suspect my third question, which is for the experts, might not give us a terribly representative view, given the number of experts who are in attendance live, but if you'd like to answer, please do. This is a question about, for the experts, ignoring your joint instructions, what best describes the split of your instructions? We have a broad church within the few experts that we have here today. We have a range of 0 to 100% claimant work, with a little in between. Thank you all very much for taking part in that. I will close the poll for now, and we'll come back to those a little later. Having got through the bad news, let's consider some judicial feedback that's more positive, and that is in some instances helpful and useful in terms of ongoing management for our experts. The first slide refers back to Mr. Y, who you'll remember was criticised in my first negative judicial soundbite slide, although relatively mildly. I thought it only fair, given that I know that there is both positive and negative feedback about Mr. Y, to show the positive feedback, and indeed to show that, of course, you can have the same expert on a different case in front of a different judge, and get a rather different judicial assessment about that expert. So here, the judge decided that the court greatly benefited from the expertise and thoughtful consideration of two eminent consultant surgeons, Mr. X and Mr. Y, and it was undoubtedly the right decision to grant permission for their testifying. They were rather different personalities, but each possessed intellect and were frank and forthright, precisely what the court would expect of high-quality experts. The court was grateful to them both, and Mr. Y in this second case was preferred on each of the four issues. This was what was said about Mr. Y in the earlier slide, just by way of comparison. I have one other example of an expert who's received positive and negative judicial feedback in the recent past, and that is that's concerned with Mr. B. In this slide, we have Mr. B included with Mr. A as being thoughtful and considered. He had a wealth of experience. When his evidence was assessed and scrutinized by the judge. Mr. B's reasoning was found to be logical and defensible, the judge in this instance found that Mr. B's opposing approach to Mr. A amounted to a genuine difference of opinion and had a logical basis. The conclusions reached were defensible when looking at all of the evidence available to the court. And just by way of reminder, the previous criticism was here. And what you'll notice, or what I thought was interesting, particularly about this, the comparison of this criticism, is actually Mr. B was commended in the second slide for being thoughtful, yet his counterpart was commended as the thoughtful, apparently the thoughtful one in the first slide. So we're often concerned when an expert receives judicial criticism. It's depending on the nature of it. It's certainly not the end of the world, and it's not a reason to panic in our litigation. I should say I have worked on cases where both Mr. B and Mr. Y have been instructed, and I recognise the positive feedback that judges have given in these slides rather than the negative feedback. I have no insight and no first-hand experience of the cases in which they were criticised, but I think it's worth saying that that's my experience of them, and I unhesitatingly would continue to recommend them. Moving on to a different case. This isn't an expert that we've looked at before, but here is an expert being praised for their conservative, clear, and persuasive evidence in reaching a moderate conclusion on the facts. Moderate and considered clearly watchwords, positive watchwords in judicial feedback. We'll come on to some positive and negative watchwords later on. Coming back to Mr. M, the judge in this case, very experienced, very well respected judge, said, presumably by way of balance, I do not mean to be unduly critical of Mr. M. I recognise that even expert witnesses may find the experience of being cross-examined challenging, and different people react in different ways to that. I have said that I was satisfied he sought to comply with his duty as an expert. However, I was left with some concern that he appeared very quick to discount factors that did not support the claimant's case and to stand by the history he had obtained, even in the face of obvious contradiction. His counterpart, the judge said, Dr. N, was more prepared to make sensible concessions in cross-examination. And Dr. N was not at all dogmatic. He was willing to acknowledge the views of other experts. He was thoughtful in giving his evidence. Although it was his view that the climatic conditions to which the claimant was exposed did not support a diagnosis, he was prepared to say that he could put those concerns aside if there was a good clinical history to support NFCI. That was a significant, in my view, appropriate concession. In short, my view of Dr. N's evidence was that he was willing to accept that there was a range of opinion, but that he adopted a narrower view of the criteria for diagnosis than many experts in the field. This next paragraph, I think, is particularly astute and insightful. And even with this effusive praise, I'm going to keep the judge anonymous, but I would say that she is, I say again, she's very well regarded, and her judgments often highlight the best judgecraft that we see. She said in this judgment, I've kept these reservations, the reservations about the experts, in mind. I've also recognized the different perspectives brought by the experts' different professional disciplines. However, my decision is not based on an impressionistic view that one expert is generally to be preferred to the other. Rather, I have carefully analysed how the expert opinions fit with the other evidence in the case. And it would be my my submission that that is the careful and the appropriate way to approach the assessment of expert evidence. It's not always the way that is adopted. And finally, in respect of judicial sound bites, I think experts should constantly remind themselves through the litigation process that they are not part of the claimant's or defendant's team, with their role being the securing and maximising or avoiding or minimising a claim for damages. The court should receive a comprehensive, objective analysis, including whether an alternative view to that held by the author is tenable. An expert must not solely pick out pieces of evidence or entries in documents which provide support for the conclusion he or she has reached, whilst not addressing material that points or may point the other way. Where there is a contrary interpretation, analysis, or view, it should be set out in the report, and it is a breach of the duties owed to the court by an expert to leave such issues to be raised by an expert instructed for the other party, by the other party. Much is expected from medical legal expert witnesses. And perhaps that's not unfair. They are the only witnesses who are paid to be in court, sometimes handsomely. They are professional witnesses. All they have to do is consider specific sets of facts which are provided to them and apply their professionally garnered knowledge, experience, and expertise to those sets of facts and give their opinions on the same. Largely, that's done on the basis of documentary evidence, but also from their own examination and consultation with a claimant. Even where there is more than one alternative set of specific set of facts in a single case. What an expert is asked to do to this point might be said to be so far so easy. That's not the title of this webinar, for good reason. The function of the medical legal expert is self-evidently straddles two professions, medicine and the law. In respect of their medical training and knowledge, they usually have 4 to 6 years of mainly study-based undergraduate training, followed by 2 years of foundational postgraduate training, and then specialty training, which varies from a further 3 years for general practitioners, for example, to 5 or 7 years in other specialties. Their legal training usually pales by comparison. Nevertheless, they're expected to have a robust understanding of legal concepts, including duty of care, standard of proof, but-for causation, and they must be able to apply those concepts to the facts of a case and nationally recognized reasonable standards. We also expect them to predict the future, usually with a degree of precision that they would avoid relaying to a patient in their own clinic. They will be challenged by the lawyers instructing them so that their reports and opinions are clear, robust, and unassailable. They will be challenged by the lawyers for the other party or parties to undermine those opinions. Those opinions will be scrutinized by some of the most analytical and logical legal minds in the country, namely our judges. It's not an easy job, but on the upside, it's certainly a stimulating one. And so to the essentials, or what I'm calling the essentials. There's nothing new here. These are repeatedly referred to in the case law, and they are at the very core of what a medical legal expert should be familiar with before they write their first report, and they should familiarize themselves with it all. If there's any doubt in their mind, at every stage of involvement in the case. Joint conferences with their instructing solicitors and barristers, joint discussions with the other side, and oral evidence at trial. It's impossible to emphasize enough how important it is for experts to be familiar with the contents of these documents. They're not excessively long, and familiarity with them will avoid the vast majority of judicial criticism. So to the first one, the Civil Procedure Rules, CPR Part 35. I've put a link to the gov.uk website for that. The Practice Directions, Part 35, 35 PD, again, another link. And the 2014 Civil Justice Council Guidance for the Instruction of Experts in Civil Claims. Again, a link there. Starting with CPR Part 35, this is only around 6 pages long. I'm not going to, because it's only around 6 pages long, and because it's essential for all experts to read and be familiar with the entire contents, all I'm going to do is pick out very brief edited highlights of Part 35. I'm going to go into a little more detail with the practice directions of 35 and scale back the detail again for the 2014 CJC guidance. Part 35, the most critical elements to be aware of are 35.3 subsection 1 and 2. An expert's overriding duty is to help the court on matters within their expertise. This overrides any obligation to the person from whom experts have received instructions or by whom they are paid. So it is crystal clear that an expert's first duty is to the court, and 35.3 makes it absolutely plain that no matter how many times you've been instructed previously by a particular firm or client, the expert is still bound to assist the court over and above the party that has instructed them. It means you really know where you stand and there shouldn't be any grey area. 35.10, an expert's report must comply with Part PD 35, as we'll come and look at. The end of the expert's report should have a statement that the expert understands and has complied with their duty to the court. And the report must state the substance of all material instructions, whether written or oral, on the basis of which the report was written. The practice directions, Part 35, has much more detail about what the expert should be compliant with. I'm going to touch on some of this detail, but again, I'm not attempting to do all of it. The practice direction is only around 5 pages long. Up front, the paragraph 2.1 reaffirms the first duty principle and makes it clear that the pressures of litigation mustn't influence an expert. And 2.2 explicitly makes the point, which is regularly taken by barristers in closing submissions, that an expert has erroneously found themselves an advocate for the party that's instructed them. We've already touched on 2.3 in the judicial feedback that we've read. 2.4, experts should make it clear when a question or issue falls outside their expertise and when they're not able to reach a definite opinion, for example, because they have insufficient information. 2.5 deals with any changes of view on any material matter and communicating that to the parties and to the court. And then paragraph 3 deals with the form and content of the expert's report, which 3.1 should be addressed to the court. 3.2 must, and it's amazing how often this rule is observed in the breach. An expert's report must give details of the expert's qualifications and give details of any literature or other material which has been relied upon in making the report. Continuing in with the form and content of the report at 3.2 subsection 6. This deals with ranges of opinion. Subsection 7 deals with summary of the conclusion, well, it specifies there should be a summary of the conclusions reached. And at 8, if the expert isn't able to give an unqualified opinion, the expert should identify what the qualification is that prevents them from doing so. At 3.2 sub 9, we have the statement that the expert understands their duty and has complied with their duty, is aware of exactly the essentials, the Part 35, the practice direction, and the guidance for the instruction of experts in civil claims 2014, and then conveniently sets out the statement of truth at 3.3, which should find itself at the end of every expert's report. Pause there to note that there is a statement of truth in the 2014 guidance that is now out of date, and it should be this 35 PD 3.3 statement of truth that that is in every expert's report. At the end of 3.3, the practice direction refers the reader to Part 22, which is statements of truth, and Part 32.14, which is the consequences of verifying a document containing a false statement without an honest belief in its truth. Again, I've put links to those two parts of the CPR on this slide for your onward research. Skipping a little further through the practice direction, this is one for both the lawyers and the experts. Where an order of the court requires an act to be done by an expert or otherwise affects an expert, the party instructing that expert must serve a copy of the order on the expert. In relation to discussions between the experts, paragraph 9 of the PD, the experts are reminded it's not for them to settle cases, but to agree and narrow issues with which they are concerned. The statement that is produced at the end of the expert's discussion, and 9.6 is a little wordy here, I would suggest. It says individual copies of the statements must be signed by the experts at the conclusion of the discussion. I don't see that happen very often. Or as soon thereafter as practicable. That happens reasonably often, and in any event within 7 days. I am not sure whether this part of the PD really needs to have anything other than within 7 days. I'm not sure it makes much difference to how it's approached. The experts at 9.7 are reminded that they don't require the authority of the parties to sign a joint statement, and reminded again at 9.8 that if they significantly alter an opinion, the joint statement must include a note or addendum by that expert explaining the change of opinion. That's important. Again, more often observed in the breach, unfortunately, probably because it can be a little embarrassing. Moving on to the CJC 2014 guidance. As I said before, I'm going to skip relatively quickly through this. This is the longest document in terms of guidance. It's 19 pages long, so we're still not looking at a great deal of reading to do. 30 pages or so in total of what I would suggest is absolutely essential pre-reading for all medical legal experts. The 2014 guidance emphasizes the duty to exercise reasonable skill and care to those instructing them, but the overriding duty to help the court. It brings to the expert's attention the overriding objective, so CPR 1, that courts deal with cases justly and that the experts are under an obligation to assist the court in that respect. So dealing with cases proportionately, keeping the work and costs in proportion to the value and importance of the case to the parties, and making sure that litigation proceeds expeditiously and fairly. There's a useful clarification of independence the term independence at paragraph 11 of the 2014 guidance. And that is in bold on this slide. A useful test of independence is that the expert would express the same opinion if given the same instructions by another party. Believe it or not, I have seen a case quite a while ago where it was clear that the expert would have given contrary evidence, but for the fact that they didn't realise who had asked them the written questions. And that case did not proceed to trial. We have a reminder at paragraph 49 of the guidance of the importance of professional objectivity and impartiality. And at 58, where material facts are in dispute, experts should express separate opinions on each hypothesis put forward. They should not express a view in favour of one or other disputed version of the facts unless, and this is fairly unusual, but unless, as a result of particular expertise and experience, they consider one set of facts as being improbable or less probable, in which case they may express that view and should give reasons for holding it. And I would suggest that the reasons are important if that is what is happening. This slide, paragraph 65 of the guidance, again is one for both lawyers and experts. It deals with amendment of reports. Lawyers rightly tend to be cautious about having draft reports reconsidered or amended, and experts rightly want to know what guidance they can accept and what reconsideration they should make in terms of their draft reports. This paragraph is pretty helpful in setting that out. Experts should not be asked to amend, expand, or alter any parts of reports in a manner which distorts their true opinion. But they may be invited to do so to ensure accuracy, clarity, internal consistency, completeness, and relevance to the issues. Although experts should generally follow the recommendations of solicitors with regard to the form of reports, they should form their own independent views on the opinions and contents of their reports and not include any suggestions that do not accord with their views. This is a reminder of an obligation for the experts. Experts have an obligation to attend court and should ensure that those instructing them are aware of their dates to avoid and that they take all reasonable steps to be available. Happily, we don't fall foul of that too often. And then I've just put some bullets here of a few other parts of the 2014 guidance that are perhaps most relevant at the moment. So experts' right to ask court for directions, that's at paragraphs 28 and 29. Addressing ranges of opinion on published sources or on no available sources, that's paragraphs 59 and 60. The usual contents of a defendant's report following sequential exchange of a claimant's expert report, that's at paragraph 63. That's one that's often overlooked, actually, where you have the claimant serving their report first, the defendant's report, broadly speaking, should be focusing on differences and disagreement between the claimant's report and their own opinions, rather than a full de novo consideration of all the circumstances. Paragraph 63 is helpful in that respect. And then finally, I've just flagged up the sanctions paragraphs, which are 89 to 92. So we come to our learning points and our little test questions, which we've got a couple more of as we go through this this section. My test questions essentially are going to be what's the most significant failure by the expert that the judge has relied upon here to prefer the evidence of the other expert? This is an easy one, it's a short one, and it's clear that the judge found that Mr. Y lacked the independence in this example. So the expert hasn't complied with 35 PD 2.1, so independent product, or 2.2, objective unbiased opinions. Dr. D, I'm going to ask this by way of poll again. So I'll launch that for you. What's the most significant failure by the expert, Dr. D, that the judge relies upon here to prefer the other expert? Take a read through of that. Any final answers? We are close. My answer to this question is that there was the failure was expressing a view in favour of one or other disputed versions of facts, which has just overtaken not maintaining professional objectivity and impartiality in the poll results. But I think it's a close run thing, that. Thanks for your participation there. The learning points for Mr. K. The first time I showed you this slide, I left out a little detail halfway through the second paragraph where the dots are. Here it is now. Judge said Mr. K trespassed outside his area of expertise and/or into my judicial functions, all which amounted to argument and advocacy, and he did so because, in my judgment, he had lost sight of the fact that his first duty was to the court. Now, I'm not asking a poll question about this because, well, there's a lot of answers to the judicial criticism here. We've got lack of independence, 35 PD 2.1, lack of objectivity, 2.2, expert not beholden to the evidence, 2.3. He's commenting outside his area of expertise, that's at 35 PD 2.2 and 2.4. He's trespassed onto the judicial function, that's the CJC guidance at paragraph 58. Coming back to the PD at 2.2, there's advocacy, and it's all because he lost sight of his first duty being to the court, CPR 35.3 subsection 1. This slide is an amalgamation of two earlier slides on Dr. M. I'll just pause for a moment so you can read through this one again. So this is another example. Why I'm not asking the poll question, because it's another example of failing to follow paragraph 58 of the CJC guidance, where all the material facts in dispute, experts should express separate opinions on each hypothesis put forward, and they shouldn't express a view in favour of one or other disputed versions of the facts. Dr. O, as I've referred to already, there were comprehensive failures by Dr. O chronicled across 7.5 pages of the judgment. The judge said she demonstrated herself to be an expert who had little or no regard to the provisions of Part 35, the practice direction and the guidance in preparing her reports. Not a glowing judicial reference, unfortunately. Coming back to Mr. P, this is an example of paragraph 11 of the CJC guidance, experts shouldn't take it upon themselves to promote the point of view of the party instructing them or engage in the role of advocates or mediators. And here's my final poll for the day in respect of Dr. S. I'll let you read that slide again, and I will launch this final question. Excellent. We're we're almost all on the right track. 65% of people have correctly said that it's not maintaining professional objectivity and impartiality. Thanks very much for your participation in all of those. Before we leave Dr. S, there are three more brief lessons that can be learnt from that case. Firstly, judges usually intend criticism of an expert to be confined to the case in which the findings are made. Secondly, the importance of the experts knowing and heeding CPR 35 and PD to Part 35 can't be overstated, and I venture to suggest that that by inference includes the CJC guidance. And thirdly, the importance of considering all material facts, to emphasize this once more, including those which might detract from the expert's opinion and or are not in the best interests of the party who has instructed them. So for ease of reference, the essential sources slide is here again. I said we'd come back to some watchwords from the case law. Our negative watchwords, we don't want to be described as dogmatic, overzealous, offhand, rude. We don't want to be described, if we're an expert, as an advocate, and we don't want to be dismissive. On the positive descriptions, we're hoping to be balanced, considered, thoughtful, independent, frank, and clear. Now, this last part of the webinar is some miscellaneous practical tips that I have for both the experts and the lawyers, but mainly to the experts actually. Please respond to your instructing solicitor as quickly as is practicable. We realise, the lawyers realise, that you may be busy with your clinical work. But as with any professional, it's incumbent on you to manage all the facets of your professional workload. You will rarely be asked to respond on an emergency basis, but please note and adhere to deadlines from your instructing solicitor. Typos happen in draft reports. We know that. It's not a big problem, but it's one that should be corrected and without undue delay. There is an argument for saying that they don't really matter, typos, and they aren't probative, and sometimes a judge will ignore them. However, it's not infrequent that the trial judge has little to go on in terms of choosing between experts, certainly when they're reading their reports in advance of oral evidence. An expert who makes no or very few typographical errors has a better starting point in the judge's mind than the other expert. Remember, I would suggest that judges in these cases were all lawyers, and many lawyers are pedants. Please be patient with the party who instructed you, asking you to reconsider part or parts of your draft report. Sometimes these will be errors that you should have picked up yourself. Sometimes these will be more nuanced and complicated points. Sometimes the lawyers will have misunderstood your position. Almost never will it be an instructing solicitor who's trying to get your goat. Write every report as though it will be scrutinised by a High Court judge. many cases settle, but you won't know in advance of drafting your report whether this is one that'll settle or whether it'll be a 2-week showdown in the Royal Courts of Justice. If you're attending a conference remotely, please make sure, firstly, that your IT works and will continue to work throughout the conference. Secondly, that you have access to and screen space for your reports, for the documentary evidence, for the medical records, and any required imaging, while still being able to see everyone else on the conference call. Thirdly, if the conference is a video conference, the lawyers want to be able to see you, so please don't plan on attending with your camera off. And fourthly, please ensure you're somewhere quiet and confidential. For example, from my recent experience, please don't attend a video conference with your camera off at a train station. No one wants more than one agenda for a joint discussion, not the lawyers, not the experts, not the judge. However, it happens more often than any of us would like. If the parties haven't been able to agree an a single agenda for your joint discussion, there's usually multiple reasons why, which the parties feel strongly about. Please consider each agenda and answer them both unless there are particular questions where your opposite number and you feel that there is absolutely no material difference in the wording. If you haven't given evidence at court often or at all before, that's not unusual. But please make time to visit a similar court when it's hearing oral expert evidence in another case. To a point, the more you do this, the better. If you can, avoid only claimant or only defendant medical legal practice. Your true split is likely to come out at trial, and it may confound your appearance of independence. The extent of your expertise is also likely to come out at trial. Have you plenty of experience of the diagnosis, of the surgery, or the treatment that you're opining on? Are you still in clinical practice? And if not, how will you evidence your expertise? If you cease to have relevant expertise, there hopefully will be a good reason for the same, and hopefully you will communicate it to those instructing as soon as possible. And finally, if possible, please plan your retirement from medical legal work with plenty of advanced warning. Generally speaking, the more valuable and complex the litigation, the longer it can take to get to trial. If you're instructed, for example, before the claim has been issued at court, so before there are particulars of claim or a defence, such cases can take 5 to 7 years to conclude at the moment. If you're instructed after issue, claims currently taking 2 to 4 years to reach conclusion. These are broad time estimates, not guarantees. Just to help consider what your planning needs to be like. That's it. Thank you very much for joining me this afternoon. Please don't hesitate to contact me with any questions arising out of these materials. All registrants will receive a copy of the PowerPoint slides without having to do anything else. And that's whether or not you were in attendance live today. Farrars is able to provide in-house training on a comprehensive range of civil litigation topics, including current medical legal issues such as applications to change experts, so the Edwards-Tubb line of authority, whether to obtain expert evidence from a particular speciality, joint discussion phases from agenda to statement. So if there's anything that you think we can help with, do get in touch with our clerks in the first instance. I will leave this final slide up for a few minutes in case you'd like to copy down my contact details. As I say, I'm very happy to be contacted directly, either by email or by phone. I'll leave this open for a couple of minutes and then we will close the webinar. Thanks very much again for being here.